I'm Matt Gishard, and this is No Holds Barred. In today's session, I want to talk about criminal jury trials. And specifically, I want to start off with the recent news about the appellate court in New York overturning the Weinstein criminal conviction. I'm often asked the question of what's the difference between a civil jury and a criminal jury? What's the matter of proof in a criminal case as opposed to a civil case, and how does it all work? Well, today let's just start off with criminal cases, jury cases. I want to say that there's the burden in the United States, and we're talking about California law, so specifically in California, the burden is on the prosecution. And that means in our system of justice, the defense doesn't even have to mount a defense during the course of a trial. If the prosecution cannot prove beyond a reasonable doubt that somebody has committed a crime, then they walk. We often hear about cases in which something sensational happened, and I want to talk about the Weinstein case, and particularly what we've been hearing in the news lately. So we know Weinstein, big media mogul. He's been convicted in California and I think sentenced to something like 16 years in prison for repeated sexual assaults on various women over the years. And he was convicted in New York State court of the same thing. And let's stop right there and talk about a question that some people ask often is, well, wait a minute, if he's convicted in one jurisdiction, why waste time in another jurisdiction? And that's always a good question. And the answer is, in one jurisdiction, perhaps a court of appeal may overturn that conviction. And so prosecutions in many cases, particularly murder cases, or in a case like Weinstein, say, no, we have jurisdiction in our state, and we're going to try him, even though he's already been convicted in New York. And that makes sense, because in the Weinstein case, the New York appellate court, the highest court in that land, in that state, overturned his conviction. Why did that happen? And let's go back to the reason. The burden is on the prosecution. And I'm a former prosecutor, and I have to say, in every one of the many cases that I prosecuted at trial, many, I never crossed the line. I never tried to put in evidence that was not admissible. And sometimes I tried to put in evidence that I thought was admissible, and the court ruled that's not admissible. It's more prejudicial than probative. And that's often what you hear. Well, what does that mean? Well, probative means it goes to some issue, but prejudicial, but it's too prejudicial. And we see that happening. Well, that's what happened in Weinstein's case in New York. The prosecution went right up to the line and possibly crossed over that line. And unfortunately, the trial judge allowed that to happen. The trial judge allowed evidence into that trial of prior assaults on women that were not alleged in the case. And oftentimes we talk about that as being, it's character evidence. So we have a juror of a bunch of dog lovers, but we're trying somebody for sexual assault. But we want to get evidence in that he abused his dog and that he kicked his dog. Well, that's way more prejudicial than probative, because oftentimes people say, well, it's just a bad guy. He even kicks dogs, for God's sake. So we're going to find him guilty. Doesn't matter what the evidence is. No, we protect the system and we protect the record. And as a prosecutor, that's a job that we do. And what is our role? It's to seek justice. It's not simply to find people guilty. It's to seek justice. And we put in the evidence that supports it, we believe beyond a reasonable doubt. We put it in front of a jury. And in most cases, the jury returns with a verdict of guilty beyond a reasonable doubt under those circumstances. But if we cross the line, if we put in evidence that's more prejudicial than probative, the trial judge has a duty to protect the record. But in my view, the prosecution also has a duty to protect the record. And it was no satisfaction in my mind, or should be in any prosecutor's mind, that you could convict somebody, a jury would convict them, but later an appellate court would say it was abuse of discretion by the judge to allow something in, and therefore we're back in front of a jury again, retrying the case or not. Sometimes it's difficult to retry a case. Witnesses in the Weinstein case in New York, the appellate court felt that the prosecution overreached, and the judge let in evidence that I would really characterize as character evidence of Weinstein that was kind of pile-on evidence. And I think from the perspective of people who've watched that and are concerned or outraged about it being overturned, the district attorney in that jurisdiction has indicated that he will retry the case. I read that in the newspaper just recently. So the case will be retried. Evidence will come in, not the evidence on which the case was overturned, but evidence will come in, and I will venture to guess that Mr. Weinstein will once again be found guilty in the state of New York for the offenses that were charged in the state of New York. And that's important to know. I want to make a statement, though, that I find particularly distressing. We were trained, and I think all prosecutors have this in the back of their mind, that we don't go out to the jury afterwards, and let's assume, and it certainly happens, any prosecutor that tells you he or she never lost a case is not telling the truth. So I had somewhere in the neighborhood of 85 jury trials to verdict in the 7 or 8 years that I spent in the district attorney's office, 17 of which were murder cases, 2 of which were self-defense cases, and they were not guilties in those cases. I frankly was very upset because there was evidence in my mind that proved way beyond a reasonable doubt in both cases that those people were guilty of murder. However, the jury returned the verdicts that they did in those 2 cases of not guilty, and it was my job not to stand outside the courtroom after it's over and say, let me tell you about the evidence that the judge didn't let in. Let me tell you how bad that guy is, or let me tell you how stupid you are as jurors. Not something we can do. What you do is you accept the system that we have, and you accept the verdict of the jury without complaint. You can complain when you get home, back in the office, you can be upset, and I was clearly upset, but we don't taint the jury pool. The reason I'm bringing this up is after the Weinstein case in New York, mind you, in New York, we had a leading politician here in the state of California say that he was outraged. Okay, that's fair enough. But also that he was ashamed of the lawyers who represented Mr. Weinstein in the state of New York. That is absolutely inappropriate. The lawyers did the job that they were supposed to do. They recognized an error on the part of the trial judge. They filed an appeal, and the highest court in the state of New York found that to have substance and overturned the conviction. That does not mean that Mr. Weinstein was innocent. That doesn't mean that people can't be outraged, particularly women, with his conduct over the course of his professional life. That doesn't mean anything of that. It simply means that our system didn't work in the short term, but we're correcting that, and the DA is going to retry that case, and that's how our system should work and will work. So I just want to mention to all of you, that's how the system works. We often hear about something in the paper, somebody was found not guilty. People are not found innocent. Now, people may be innocent, but a jury's job in the United States, in all states, is somebody is either guilty and beyond a reasonable doubt, and in California, among most states, it has to be unanimous. So 12 people have found that the evidence supports a finding of guilty beyond a reasonable doubt. When somebody is not guilty, and the finding by the jury is not guilty, that doesn't mean that they're innocent. That means, like the 2 murder cases in which defense verdicts came in when I was a prosecutor, that means that we did not prove beyond a reasonable doubt to the satisfaction of that jury that the person was guilty. And that's how our system works, and it should work like that. And I'm going to finish off with this concept. We have, during these times here in the United States, an attack on the judiciary, an attack on our legal system, an attack on prosecutors and defense attorneys. We have a well-defined system. We've had it for many, many years, as long as we've been a country in existence. And for the most part, that system works quite well. And what we need from all of our citizens is recognizing that is our system. Those are the rules of law that we have. And our system cannot work if our citizens have no confidence in our system. And we don't ever want that to happen. So I submit to you, whenever you hear somebody who's on trial, somebody who's a big shot politician, somebody who's doing it for personal reasons, perhaps to get elected to an office, attacking our system, attacking our judges, attacking prosecutors, attacking defense attorneys, that is absolutely a no-no. That's a no-no. So, thank you for listening. If you have any comments, certainly put them into the comment section, or any questions. I'm always happy to hear. In fact, one of the reasons why I decided to talk on this particular podcast is for the very reason that people have asked me, what happened in the Weinstein case and how does it all work? Thanks for watching this episode of No Holds Barred. Hit the like button and hit the subscribe button. And what I'd like to say about No Holds Barred is no hyperbole, no bullshit, just the law and the facts. The reason why we like you to hit the like button and the subscribe button is because it helps us with our YouTube rankings. The more people that do that, the more people will watch our episode, the more comments we get, the more questions we get, the higher we go in the rankings. It helps you, and it certainly helps us.